He is screaming so loud the veins in his neck look like they might pop through his collar. He points at me, sharp, theatrical, and roars, "She's an embarrassment." The whole courtroom leans in. The mahogany walls seem to listen. The judge's eyes flick over the files, calm as a closed lake. I say nothing. I watch his face, the red bloom of certainty, the way his hands tremble with entitlement. It's 10:02 a.m. on my watch, right on schedule. Before the roar finishes, before the judge can ask the next question, there is a hush that isn't natural. It's the kind of quiet that precedes something significant. People clear their throats. The bailiff's shoes scuff. Bennett, my father's attorney, glances at Richard with that look lawyers get when they know their client just said the wrong thing. I let the silence sit on record. That silence is deliberate. I've been practicing it for years. If you're hearing this now, drop a comment. Where are you listening from, and what time is it where you are? I am not here because I want control. I am not here for an inheritance. I am here for one simple thing: my freedom. The memory that brought me to this courtroom starts at a table under dim Christmas lights. It was a few years earlier, Christmas Eve, and he joked in front of my cousins about how I would never be anything more than a helpless little girl. There was laughter from the wrong side of the room, the kind that sounds like permission. He called me delicate, then unstable, then loud enough for the conversation to circle me like vultures. It was mean, casual cruelty dressed up as wit. I felt every eye become a verdict. Afterwards, I went home and sat on the floor of my kitchen, pulling envelopes out of a drawer. I had paid parts of his mortgage for months without telling anyone. I had quietly covered things because I thought love looked like keeping the house intact. That night the word helpless lodged like a splinter under my skin. It was not the first time he tried to erase me. There was a morning a few years before that, when I got a call from a nurse who'd been coaxed by a note I later learned was forged. The next thing I knew, someone was telling me my father had initiated a 5150 hold, an involuntary psychiatric hold, saying I was a danger to myself and others. There were falsified medical statements, signatures that didn't belong to the doctors they claimed, and a cascade of small, efficient lies meant to make me disappear into a system that moves with the inertia of a glacier. The hospital let me go eventually, but the intent was unmistakable. Make the daughter a patient, not a person. I could have called the police. I could have dragged him into court on fraud charges. I sat in the small light of my apartment and tried to imagine what justice would feel like. Anger did not help. Fury, naked and loud, would have been satisfying for a week. It wouldn't have fixed the mortgage, or the bills he was collecting in my name, or the long trail of humiliation in front of my family and colleagues. I wanted a resolution that left me free to breathe and left him without the power to try that again. So I planned, quietly, deliberately, not out of spite but out of self-preservation. It's important to say, right here, that this is my story, a sequence of choices I made for myself. It is not a how-to. I do not give legal advice. The mechanisms I used worked in this situation. They may not work elsewhere. Some procedural specifics are indefinido and were handled with counsel at the time. I formed a company, Vanguard Holdings. The name sounds grander than it is. I wanted something unremarkable enough to pass with a signature and precise enough to be a legal entity. I put capital into it, real capital, money I had earned, money I had saved, and planned not to spend. The goal wasn't to run a conglomerate. The goal was to hold a position that meant legal standing, to purchase the debt he had on a small commercial loan that he had guaranteed personally and had tied to his firm's assets. You can think of senior secured creditor in plain language like this. Imagine a line of people with tickets to take things if the borrower can't pay. Being senior means you're first in line. Being secured means there is a lock on something valuable attached to the debt. If the borrower defaults, the person at the front of the line collects the collateral. That is the position Vanguard ended up in. I didn't own the company he worked for. I owned the lien on the things he had used to back the loan. I remember the day we closed the purchase of his loan. I sat in a conference room with my attorney and signatories whose names I barely recognized. We injected a capital infusion, $650,000, into a structure that on paper made it clear the money would be applied in a way my father could not redirect without consequence. I watched the wires move like the tick of a metronome. The numbers were dry, clinical, principal, interest, collateral descriptions. But behind those numbers sat a human story of leverage. Richard had been gambling with the firm. He had been reckless. My capital did something very ordinary. It replaced his option with mine. There is a particular kind of silence that follows the realization that someone has been calculating. It is not vindictive. It is the piece of a plan executed. Months later, when irons had cooled and the papers had quieted into public record, my father attempted the ultimate move, a conservatorship petition. He filed in court claiming I was mentally incompetent, that I could not manage my own affairs. He is a lawyer by trade, a man who has spent his life learning how to shape narratives so they look more like fact. He expected the courtroom drama to play out in his favor. He misread the room. The hearing begins with the ordinary formalities, the swearing in, the rustle of papers, the judge's pen tapping twice like a heartbeat. I listen to him speak. He paints me as scattered, as someone who can't handle money. He leans into the theater of it, the pitying glance at the family members he brought with him, the rhetorical sigh. He calls me unstable on record. He says I am an embarrassment. This is the moment the title promises, the public spectacle where the father yells across the mahogany and the gallery gasps. I remain silent. I do not smile. I don't smirk. I don't clap back. Silence is a strategy. It is a lever. He demands action. He asks the judge to make me a ward of the court. He expects the audience to nod at his performance. Bennett gestures for sympathy, for nods. Instead, the judge narrows his eyes and says nothing for a beat that feels like a small eternity. Then Judge Sullivan leans forward and opens a thick binder from the clerk's table. He flips until his finger finds the place he's obviously looking for. The leather creaks. He reads, slow at first, then with that unmistakable clarity judges have when they are about to remove the curtain. Vanguard Holdings, he says. The sole incorporator listed on these documents is Illa Caldwell. Those words land like a soft but inexorable weight. The room exhales. A few people shift in their seats. You really don't know who she is, do you? Judge Sullivan asks my father, not unkindly, but sharply enough that the laugh that follows in the gallery stops before it finishes. Time compresses. Richard's face drains to a color I don't have a word for, an embarrassed gray. He opens his mouth to answer, and nothing comes out that lands as a defense. Bennett's hand sweeps papers into a small storm. I can see the calculus changing in his face. He had built his counsel around the assumption that reputation and performance in front of people win cases. They do not win against documents. The judge asks to see the loan file. The binder is heavy and thick with redactions and photocopies and exhibits. He reads aloud from the promissory note, the clauses that, on paper, allow the lender to declare a default if the borrower misrepresents material facts or suffers a character default. The exact legal contours of the clause, the precise triggers and their interpretation, are complicated and, I will say plainly, indefinido in terms of universal application. In our case, The document's language was plain enough to allow the judge to treat on the record statements as evidence that the borrower had materially misrepresented the situation, thus permitting an acceleration of the loan. Acceleration, said plainly, means the lender can demand the entire balance immediately instead of making payments over time. It is like the bank saying, "You're not playing by the terms. Give us everything now." That is the point where being a senior secured creditor matters. If you are first in line and the debt is accelerated, you can seek to enforce the collateral provisions. I explain this not to teach, but to translate. Legal paperwork turned my father's words against him. His public accusation that I was incapable, his demand that the court strip me of my rights, became a trigger under the very contract he had used to secure his firm's financing. It is an uncomfortable inversion. His attempt to make me less than led to his loss of leverage. That is the theater of law. The page can be blunter and more damning than any speech. When the judge asked, "You really don't know who she is, do you?" He was less concerned with my resume than with the question of whether the man with his hand on the gavel had been presented with the full documentary truth. The binder made that truth stubborn. Bennett sputtered some objections, his objections tying at the seams, but the judge had the look of someone who had made the decision to let records speak. He signed an enforcement order. He allowed, in his discretion, the relief requested by the creditor, relief that included seizing listed collateral and an order permitting a locksmith and other enforcement agents to take possession. Those words landed like a thunderclap. My father's posture, so full of drama minutes earlier, twitched. He tried to clap like a man adjusting to a shock. The motion came off small and ridiculous. "You can't," he began, but the judge's pen carved through the sentence. "I don't celebrate the moment the bailiff turns to the clerk and instructs them to call the firm's liquidation team. I do watch, clinically, as consequences proceed in the only way they can when paper authorizes action. A locksmith is called. A notice is affixed to the door. Men with clipboards come and inventory. The firm's mahogany plaque, once polished, is placed into a plain cardboard box. There is no pyrotechnic finale, no dramatic toppled statue, just the hollow thud of an office chair being carried out the door. Richard's hubris collapses into something quieter and lonelier than my expectations. He looks smaller than he ever has in my memory. There is a private humiliation that no one cheers for. It is a human thing that makes me look away. My satisfaction is not a shout. It is a closing of a door. In the days after the hearing, teams showed up to execute the order. The locksmith drills, and then the lock clicks open, with the same dull relief as a breath exhaled after holding it too long. A liquidator catalogs art and computers, boxes are taped up, and an office that had been a stage for my father's authority becomes an inventory list. Banks place holds, and clerks make phone calls that sound like minor rituals of the undoing of a life built on performance. There were practicalities I had to witness because I wanted to be sure the enforcement actually happened, because in my life, paper means nothing if not enforced. I watched the locksmith, the firm's plaque in a box like a small tombstone. I watched as the man who once lectured me on propriety and self-control walked the length of the sidewalk like someone in a country song about broken things. I did not gloat. I was present, quiet. Relief felt like a room with windows finally opened. I deleted his number from my phone. The moment I pressed delete, I felt a strange lightness. It was not vindication so much as closure. A relationship had been eaten away by a decade of small humiliations, public jokes, a willingness to place me in a hospital for convenience, forged documents that redefined my personhood as a liability. Deleting his number was a practical finishing move. It was the equivalent of locking a closet that would no longer be entered. I did not text him a photo of the cardboard box with his plaque to rub it in. I put the phone down. I walked to the window and held my hands there until the chill in the glass reminded me I was still alive. People often want a sharp moral at the end of stories like this. Either revenge is bad or revenge is sweet. I resist both. My actions were about survival, not malice. I set legal levers into motion because my father had weaponized institutions against me. I turned institutional language back against the weapon. That is a morally gray place. I felt no pleasure in the shrinking of his world. I felt the quiet assurance that I could no longer be made into a patient, a ward, an embarrassment without cost. There is another truth that sits with me. Documents lie, but also reveal. His words, shouted in front of the judge, were intended to summon pity. Instead, they became evidence. The judge's voice that day was less a moral adjudication than a procedural correction. The record will show, the record will speak, and the court will act according to what the document provides. It felt like a small miracle of bureaucracy, cold, impersonal, and perfectly fair in its own way. Bennett pleaded for continuance. He tried to find errors. He accused clerks of redaction mistakes. None of those maneuvers unspooled the fact that the ledger of ownership and the chain of promissory notes were as they were. The law is sometimes a blunt instrument. At its best, it is boring and methodical. The judge gave the order. Enforcement followed. The firm's key was changed. People who had depended on his charisma suddenly had to learn how to depend on something less malleable, a contract. As I walked out of the courthouse that day, people leaned forward in a kind of imperfect curiosity. Some looked at me like they wanted a soundbite, a line to put on a page. They wanted the "I told you so" or the cinematic coda where I flip my hair and walk off into the sunset. That wasn't the point. I felt, rather, a conservational calm, as if a weight I hadn't known I was holding had finally been set down. A few weeks later, there was the slow, administrative unraveling. Phone messages left unanswered by former partners, the mail forwarding sign, the names being crossed off the firm's door in carefully stamped letters. An auction notice, a bank letter, a small local news inquiry that wanted to make of my story some parable about filial duty. I said no to interviews that wanted spectacle. I said yes to checking that the enforcement had been executed to the letter, and then I let it go. There are moments people imagine when they think of stories like mine: a courtroom stare-down, a dramatic shouting match, a mic drop. The real power of that day was quieter. It arrived in the precise articulation of a phrase in a binder, in a judge's willingness to let paperwork do what speeches could not. The loudest noise in the courtroom was his shame, not my triumph. I will admit something that feels small and private. The first night after the eviction, I slept better than I had in a long time. There was a relief so physical, I could feel it in my jaw unclenching. That relief was not a thrill at watching someone fall. It was the deep remedial kind that follows a long period of being undermined. I had used my mind to create a boundary around my life, and the boundary held. People write to me sometimes, asking what I would have done differently. The honest answer is that I wish I had confronted the cruelty earlier and directly, that I wish conversations had happened before the escalation. But people who spend a lifetime rationalizing their worst impulses are difficult to reach. When the instrument to protect yourself presents itself, legal counsel, documentation, capital, some people use it to rebuild, not to punish. I rebuilt. I tell this part plainly because there is a temptation to mythologize. I am not heroic in some cartoonish way. I am careful, persistent, and not afraid of paperwork. Those traits serve someone who wants to keep her freedom. I also kept a sharp eye on compassion. If the universe had arranged for him to fall into ruin as a moral lesson, I would not be the one to stand and clap. My job was to ensure an attempt to erase me could not be repeated. There is one image that still lingers, the locksmith's drill, the dull music of metal grinding through metal, the small pile of nameplates by the stairwell. I watched as a man carried a little box with his office placard and placed it gently on the curb. It seemed to me then that a lot of the things, the trappings of success, are simply objects. They hold a kind of narrative value because someone tells a story about them. Remove the story, and they're stucco and brass and wood. I am not indifferent to the human cost. Stripping someone's office carries consequences that ripple beyond an individual's ego. There were staff who had to find work, colleagues surprised by sudden vacancies, clients with contracts to fulfill. I hired help to ensure that the people affected by the enforcement were treated with fairness, paid what they were owed, given referrals, help to transition. I refused to let my action create collateral humiliation for people who had not willfully harmed me. In the everyday aftermath, my life is mostly the same small things. I go to work. I meet clients. I pay my bills. I make small plans for a vacation next year. The drama of the courtroom is a sealed chapter. There is, however, a persistently softer edge to how I live my life now. I answer calls with less fear. I do not flinch at old jokes about my weakness. That is not because I want to teach him a lesson, but because I want to be free again in ways that matter. To walk without bracing for someone else's mockery. To speak my mind without fearing institutional retaliation. That day, the judge shocked us all. He asked a question that served like a mirror and showed a truth none of us wanted to admit publicly. He didn't humiliate my father. He simply put the documents on the table and let the law do what it is sometimes designed to do. Correct an imbalance. My father's screams, his "she's an embarrassment," echo around the internet in headlines and sound bites. But in the quiet of my apartment, there is only a memory of the binder snapping shut and the finality of a signature. If there is a lesson in all of this, if people must take anything away, let it be simple. Agency matters. Being able to act with deliberation, to prepare, to use the tools available to you to protect yourself, is not cruelty. It is an assertion of your right to exist without being reduced to someone else's punchline. That assertion looks different for every person. For me, it looked like paperwork and patience, and an unwillingness to be erased. I do not pretend every family conflict ends this way. Most do not. Most of our fights never reach the courthouse, and even when they do, outcomes are messy and imperfect. This is my story, not a universal manual. There were dark moments, anger, regret, nights I relived humiliation, and there were pragmatic choices that created space to breathe. Now, when people ask whether I feel victorious, the answer is nuanced. I feel relieved. There is a serenity that is not celebratory, but restorative. I don't post pictures of the courthouse outside. I do not make a spectacle. I delete the number and walk forward. If this story resonated with you, if you've ever had to reclaim your agency, or if you've watched bureaucracy and courage intersect, consider subscribing for more true courtroom stories. Share this with someone who needs to know they aren't alone in the quiet work of protecting themselves.